I'm going to start off the talk with the scope of telehealth services with a legal and ethical perspective. Just to very briefly tell the viewers that telemedicine is nothing but some technology which helps the doctor and patient to meet when the patient cannot meet the doctor physically. What it also means is that with the doctor and patient, the health laws and ethics will apply, technology with technology laws will apply. And this is what leads to telemedicine. And this is going to be the discussion for the next 15 minutes. So if you look at the scope of telehealth services, it will depend on the timing of information transmitted, whether information is being transmitted real time or asynchronous or not real time. So depending on that, your scope of telehealth services will be decided. Today, with 4G available and 5G coming, synchronous is becoming more and more popular, but asynchronous has a lot of roles still to play, especially with email, second opinions, the images being transferred and so on. So when you combine both synchronous and asynchronous, you get these apps, software and applications, which actually are the way forward that the government of India hopes that telemedicine will take off in the country. The scope of telehealth services also is a function of bandwidth, latency, and complexity of care. This slide I've taken from Oxford and very beautifully describes that according to the scope of your telehealth services, if you want to go for high definition video kind of procedures, then you require a very high bandwidth, low latency. But if you require only to do email consultation, then asynchronous or low bandwidth is enough. And if you want to do a video quality, then again, a middle level bandwidth is required. There may be a little bit of latency, but that doesn't matter. So this slide very beautifully projects the scope of telehealth services and the scope of technology in providing those services. So let's look at the telemedicine laws that apply in India, the Indian Medical Council Professional Conduct Etiquette and Ethics Act, and telemedicine, how that kind of comes in, and scope of implementing teleservices from ethical consideration in implementing the telemedicine practice guidelines, which has been given by the government of India. If you look at the health laws which apply for telehealth services, the Indian Medical Council Act, which I already told you about, the Professional Conduct and Etiquette Act will apply. And this includes the telemedicine practice guidelines. Then, by the way, it is the chapter 3.81 of that act in which the telemedicine is included in Appendix 5. Then the Drugs and Cosmetic Act of 1940 will apply. That's a drug list in telemedicine practices. Then the Clinical Establishment Act will apply. The ICT laws, various laws like in IT Act will apply of 2000. Then the Information Technology Intermediaries guidelines will apply, telecom law will apply. But in none of these laws as such, telemedicine or digital health has so far been included or mentioned. It will be required when hardware and software is being spoken about. When you talk about malpractice law that apply, for endangering life, section 336, for causing hurt or grievous hurt, endangering life or personal safety, section 337 or IPC 338 will apply. The most dreaded law is the death by negligence, 341A, and is the most dreaded, and that will apply. The Indian Medical Council Act has 8 chapters, but the chapters which are important from telemedicine includes this chapter 1, 2, 3, and chapter 6. When we become doctors, we take this oath and we sign this. We are supposed to sign this. I shall abide by the code of medical ethics as enunciated in this act. And it actually says everything in the, all the 7 chapters you need to be familiar with. The scope of telehealth implementing services, when you look at, you will look at cross-state telemedicine practice, whether it's allowed or not, standard of care as defined in the practice guidelines, the role of intermediaries and consent process, how long to preserve the records, confidentiality, breach, and advertising. What does it say? So what does the MCI or NMC law says about cross-border, cross-state telehealth consultation? It says that if you are registered with the state medical register or Indian medical register under the Indian Medical Council Act of 1956, then you can practice anywhere in this country, no problem. And there was actually something which went to Supreme Court on this, and the Supreme Court also very clearly said the same thing, that you can practice anywhere in the country once you are registered in one place. So this will work well for telemedicine practice. So we don't have to worry about this area. As far as standard of care is concerned, this is a bit of a worry. The telemedicine practice guidelines say the RMP will uphold the same standard of care as in face-to-face or in-person consultation, but within the intrinsic limit of telemedicine. What it does is, it actually doesn't, standard of care is not well defined in this telemedicine practice guidelines, and the interpretation can be very ambiguous. And this is a bit of a worry. The scope of practice, practice and limitation of telemedicine needs definitely better definition, because standard of care will depend on experience of the professional has, the training a professional has, how many times they do knowledge updation, and no two similar situations are alike. And when there is a case in the court of law of, against a doctor, then when you look at standard of care, this will be, whether it's breached or not, will be determined by the, by the opposition party, by the trier of fact, and the judge. And the judgment can vary depending on how the standard of care is presented. Because sometimes a serious complication can only be visible to a doctor retrospectively that the judgment was wrong. So it is not so easy when you talk about standard of care. As far as informed consent is concerned, the language of consent and the terms and conditions, especially in the apps, are not easy to understand. They are basically convoluted legal jargon as far as the doctor is concerned. And the consumer will be invited to download, the doctor will be invited to download these terms and just say, I accept and go forward. Now, whereas when you do medical research, this is informed consent is very well defined, whether it is with the patients, and it protects the subject very well. We all know that. The scope of implementing teleservices as far as the intermediary or the app developers and software developers is concerned, and the liability issues, who will bear the liability issue? Because at the moment, the IT app company for consultation is considered to be an intermediary, despite being a beneficiary. So usually they charge a facilitation fees, but is not liable under the rules regulating the practice of telemedicine. So this needs to be better defined. What about the liability issues with online pharmacies? They are considered to be aggregators and they cannot be prosecuted. So this again needs to be defined. So there are these gray areas which we need to have better kind of clarity as we go forward. When you're consulting, a patient is consulting and the documents needs to be preserved. How long should it be preserved? The guidelines itself say it is incumbent on RMP to maintain the following records and hard copy of the document for a period as prescribed from time to time. It doesn't say anything further than that. So that's why you go back to our, the Etiquette and Ethics Act of MCI, and there it says that it should be preserved for 3 years, and I'll come to that. But as far as telemedicine is concerned, you need to actually keep the logs, the phone logs, email records, the chat records, video interaction logs, not the actual video interaction as far as telemedicine is concerned. So this is what you need to preserve, the logs, and you can capture the video image for patient identification, but you don't need to record the whole video conversation. And prescription needs to be preserved for a very long time. The patient's records, document, images, diagnostic data again needs to be for teleconsult needs to be preserved. And you need to inform the patient and seek permission before capturing the images for storage. If you look at as I said, our act, our MCI Act, it says every physician should maintain the record for 3 years from date of commencement of treatment. So this is what we are proposing in telemedicine when we also do the training. And if there is a request, then within 72 hours, you have to reproduce the same. And also this, interestingly, the 1.33 says that, 1.34 says efforts should be made to computerize your medical records for quick retrieval. So there is already a clause in our, MCI and NMC Act on preservation and on computerizing your medical records. There are many certificates which a doctor has to, if you are going to issue this certificate, all the certificates needs to be preserved. As far as image is concerned, from video capturing, a psychiatrist, if he's doing a consultation, let's say, and there is a seizure or an abnormal behavior, he may want to capture that. A radiology image may be captured, a lesion of the skin, oral cavity may be captured, but always inform the patient and seek permission before capturing such images. What about privacy and confidentiality issues, which was being talked about earlier by Dr. Diman? Digital consult will leave an electronic footprint, and it is prone to issues of security and confidentiality. And because video consultations are never going to be 100% confidential. Both doctors and technicians are part of the teleconsultation process. There can be also flaws in the technical equipment. So, what do you do about that? Because the MCI Act says on this that on confidences concerning individual or domestic life entrusted by patient to a physician and defects in the disposition or character of the patient observed during medical attendance should never be revealed unless their revelation is required by the state of law. So our law is very clear, but with teleconsultation, you cannot have 100% confidentiality. And this clarification needs to be done in chapter 2.2. We need to further have a consultation. Further have something written here to be more kind of, feel more confidence when we're doing teleconsultation. What about emergency services and the scope of teleconsultation? You can give first aid advice as said by TPG, but also you can inform the local police, ambulance service for emergency intervention to save a patient's life. Or, if there is a homicide or attempt to suicide, then you should be able to do that. Now comes to the chapter 6, unethical acts, especially about advertising. This is another gray area which we have to tackle in our law and in our TPG, in our telemedicine practice guideline. What is advertisement? There are 3 components. Information is allowed. Persuasion, both cognitively or emotionally, is not allowed in advertising. And to remind, this is not allowed. So advertising consists of 3 things: inform, persuade, and to remind. You can inform, you can remind, but don't persuade. That is not allowed in the law. And the TPG itself says the soliciting the patient directly or indirectly by a physician, by a group of physicians, or an institution or organization is unethical. This is what NMC says, the MCI says, the TPJ says, same thing, do not solicit or advertise or give inducement for teleconsultation. RMP should not insist on telemedicine when patient is willing to come for in-person consultation. So a medical practitioner is permitted to make certain things and certain things is not permitted to do. What is he allowed to do? He is allowed to advertise on starting a practice, change of type of practice, change of address, temporary absence from duty, resumption to another place, public declaration of charges, and so on. What is not allowed is printing of self-photographs and publicity and so on. But we know there are a lot of print media has a lot of doctors' photographs, a lot of editorials come up in the newspapers, in the television, but so far no one has been prosecuted. So why have this area? If there is, we are not following it in the, in principle. So this needs again to be addressed in our NMC, MCI Act as such. Prescription medication. Now there is a word called etc. all over the place in this. There's no clarity. Why can't the list be better enlarged? This again doesn't give confidence to doctors. And this is a point of, discussion in all the training programs which you do. What does this etc. mean? How do we interpret this? So we need more clarity in this area as well, if you want to improve the scope of telehealth services. One of the issues is a great amount of digital illiteracy about medical ethics and law. It is not only with the public, but also with the doctor, especially the lack of awareness regarding privacy concern, risk assessment, societal impact, regulatory requirements, and so on. And many of these funding, people like the VCs, the technologists, the data scientists, who invest in health technology have no idea of these kind of ethics and law. So a lot of things are, kind of the regulations are, kind of overlooked when they launch these services. And the biggest danger of digital illiteracy is false sense of security. I have had this problem. In this COVID pandemic, I have had patients who I know have cancer, who needs a prosthetic biopsy, and I've told them repeatedly, please come and have a biopsy in the hospital. They will not come. They'll say, Dr. Saab, let the pandemic stop, then only I'll come. So they do a teleconsultation and it gives them a false sense of security. Doctor has given some advice. So this is one of the dangers which I have realized of the digital literacy in this pandemic. So this false sense of security is something which we need to look at and can be detrimental in providing healthcare and can limit the scope of teleservices. So this is my last slide. So in summary, the scope of teleservices requires more clarity. Amendments are required in the Professional Conduct, Etiquette and Ethics Act, the Drugs Cosmetic Act, and ADI Acts. We need more clarity on limitation of what defines standard of care in teleconsultation. The liability of intermediaries and aggregators does not exist. It needs to be better defined. Video consultations, more clarity on privacy and confidentiality issues is required. Publishing of photographs of doctors or making announcement needs further clarification. List of drugs need to be spelled out. properly, what can be given, what can't be given. The current act excludes government offices from its purview. Not sure why this has been done. So a lot of these things need to be addressed so that we can improve the scope of teleservices and doctors out there can embrace this technology without any fear as we go forward. So thank you very much. And I look forward to listening to other speakers. Thank you.